Peace, 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 everyone. It is your girl, Empress ShayMarie, back for another recording. Hope you all are having a lovely day. Happy Thursday to you all. Today is October 13th, 2022, according to the Gregorian calendar. So we're going to pick up reading the Gilbert Law Summaries book on trust. I kind of ended in the middle of chapter 2 yesterday. And so we're going to continue reading chapter 2, and then I'll probably read for a couple of hours. So with that being said, I hope you are appreciating the reading and the information that is being shared here. That is extremely valuable. A lot of different things are coming to light. I want to please say, excuse my voice. The weather is changing. We're going into a different season. And I have been using my voice a lot extra lately. So please excuse the different pitches and tones and scratchiness that may occur as I'm reading. Moving on. So yesterday we were talking about in the reading, we were going over information about the purpose of the trust, beneficiaries, breaking down the trustees' duties, and all of these different things in regards to trust, right? We left off talking about the technical rules of the common law, the doctrine of worthier title. Okay. So here on this table, it says you have rule, you have the rule, you have example, result, modern status, and modern result. And so then it's divided into two sections. So the left section is in regards to the doctrine of worthier title, and the right section is in regards to rules in Shelley's case. Okay, so the rule for the doctrine of worthier title is remainder to transferors, heirs invalid. Transferor has a reversion. The rule in Shelley's case is remainder to life estate holders, heirs invalid, becomes a fee simple. Okay, so you have example for the doctrine of worthier title, which says that S transfers to T in trust for A for life, then to my heirs. And then for the rules in Shelley's case, it's S transfers to T in trust for A for life, then to A's heirs. The result for doctrine of worthier title is that A has a life estate. S has a reversion. Okay. And the result for the rule of in Shelley's case was A has a fee simple. The modern status and doctrine of worthier title was abolished in most jurisdictions, has been treated as a rule of construction, such as, or i.e., raising a rebuttable presumption. And in regards to Shelley's case, it was abolished in nearly all states. Modern result for the doctrine of worthier title, A has a life estate and S heirs have a remainder. And the modern results for rules in Shelley's case is A has a life estate and A's heirs have a contingent remainder because A's heirs are unidentifiable until A's death. Okay. So it says to caution, formal requirements must be satisfied for identification of beneficiaries of testamentary trust. Section 190. In the case of a trust created by the settler's will, the beneficiaries must be identified in the will or in a codicil or by other admissible evidence, see below, and the will or codicil must be valid under the status of wills, i.e., the will must, among other things, be executed in accordance with the applicable Wills Act. Turn on my captions. Okay. All right. It says, similarly, an inter vivos trust may have to satisfy the statute of fraud, see Infra 302-346. It's weird. I looked up inter vivos trust, like examples of inter vivos trust this rising. And what came up was like very, very, very exciting to me. The examples or the type of examples that came up was examples of a living revocable trust. So I'm like, okay. All right. So continuing on, it says a reference to extrinsic writing, 191 section. Where a will does not identify the beneficiaries, but involves reference to another document, I'm sorry, guys. Please forgive me. I was trying to turn on these captions here. Okay, let me make sure they're on. Okay. All right. It says reference to intrinsic writing. Where a will does not identify the beneficiaries but involves reference to another document, that document must either satisfy the requirements of the applicable Wills Act or must satisfy the requirements of the doctrine of incorporation by reference. The doctrine, which allows the intrinsic document not present at the time the will was executed to be incorporated into the will, may be relied upon to complete the terms of the will. See will summary and see discussion of pour over wills, infra, section 367. Reference to acts of independent significance, section 192B, where unnamed beneficiaries of a testamentary trust are to be ascertained by a formula or description. That identification must be based on acts of independent significance. Under this doctrine, a will may dispose of property by reference to acts or events that have significance apart from their effect on disposition made by the will. See Will's summary. Example, a bequest, quote, to Henry Axford in trust for such person as he believes most deserving for having cared for me in my last illness, end quote, is enforceable. The beneficiary is ascertainable from circumstances outside the will that have an independent significance. In cases of doubt, the court can receive intrinsic evidence to determine the person entitled to take. Moss versus Axford, 1929 in Michigan. I like the fact there's a lot of case references from Michigan and different literature that I can find and read, seeing that I'm from Michigan. Okay, it says determining definiteness of beneficiaries under private trust. I really can't see what this says. It says to determine whether the definite beneficiaries requirement is satisfied, ask yourself the following questions. I guess I can't see it. It says, are the beneficiaries specifically named in the trust terms? Are the beneficiaries presently identifiable from intrinsic facts, such as incorporation by reference or acts of independent significance? Will the beneficiaries be ascertainable by the time their interests are to come into enjoyment and with the period of the rule against perpetuities? Number 3, class gift. Section 193. A private trust may, and usually does, at least in part, benefit the members of a class of persons. These persons are trust beneficiaries and their interests are valid provided the designated class is described with sufficient certainty that its membership is or will become reasonably definite and ascertainable within the period of the rule against perpetuities. See Infra Section 204. A. Some special class gift question. 1. Was a class gift intended? Section 194. Assume the settlor conveys to trustee and trust for the directors of the XYZ Fraternal Society. Is this gift to the directors as a class, or is it intended as a gift to the association? Cases of this type are generally resolved by intrinsic evidence of the settlor's probable intent. If the gift is construed as one to the association, this may raise the problem of whether an incorporated group can be the beneficiary of a trust. See Supra Section 179 through 181. Number 2, when is the class determined? Section 195. Assuming a class gift was intended, did the settlor intend to benefit the present and or future members of the class? This is merely a problem in construction of the trust instrument and is frequently encountered in gifts for a person's family. See below. Exam tip. It appears that the settler intended to benefit future class members. The identity of the future beneficiaries must be ascertainable within the period of the rule against perpetuities for the trust class gift to be valid. See Future Interest Summary and see Infra Section 241 et sec. B. Effective trustee or other person having power to select among class members, Section 196. Trust interests for members of a class are normally uncomplicated where the class members is limited and definite, and where the class members receive the property or benefit in equal shares or in other fixed portions. Frequently, however, a trustee is given the power, perhaps couched in terms of discretion, to select and to allocate or apportion trust benefits among one or more members of the designated class. Trusts based on such powers are clearly valid. Restatement 3D, Section 45. If the class is sufficiently definite, see Infra Section 205. But if the class is not sufficiently definite, a trustee's power of selection will normally not make the class definite or render the potential beneficiary sufficiently ascertainable to sustain the trust in many American jurisdictions. But see Restatement 3D 46 2 UTC Section 402 and Infra Section 216. Number 1, amount of gift need not be certain. Section 197. The fact that the amount distributable to each member of the class is uncertain, such as merely because the distributions are subject to the trustee's discretion. Even uncontrolled discretion does not impair the validity of the gift. As long as the class itself is sufficiently definite, the trust will be upheld. A. Trustee's discretion, Section 198. If the trustee or third person is given the discretionary power to distribute among a class, the usual interpretation is that the trustee has the power to do so selectively, i.e., can give all to one or more of the class and exclude everyone else. Restatement 3D, Section 45, CMT. C. There is nevertheless the possibility that a particular exercise will be found to be an abuse of discretion. See Restatement 3D, Section 50. B. Successor trustee appointed if trustee fails to act, Section 199. On the other hand, if the trustee fails or refuses to exercise his discretion as to which members of the class shall take, the court may appoint a successor trustee who may exercise the power provided the court finds that the settlor would so intend, i.e., that the power is not personal to the original trustee and that the trustee's non-exercise was improper, not what the settler had intended to permit, or the court may, if deemed necessary, direct distribution as a matter of construction, having all members of the class share equally, or perhaps according to some other principle, such as that of representation or per stirps. If the class is someone's issue or descendants, see Scott's on Trust, Section 120. Power of trustee to appoint to himself, Section 200. If language of trust is used or the power holder is referred to as a trustee, and if the class of appointees is broad enough to include the power holder himself, such as to trustee in trust for himself or for any other worthy person he may select, end quote, the purpose will probably not fail, although the class is indefinite, for the court probably will treat the transfer as a beneficial gift to trustee, allowing trustee to choose himself or anyone to have the property, or possibly referring to trustee as the beneficial owner, subject to a general power of appointment. Townsend versus Gordon, Michigan, 1944, courts. However, tend not to construe powers given to trustees for vague classes, such as, quote, to trustee as trustee for such of my friends as he deems most deserving, end quote, to be beneficial to the trustee. Clark versus Campbell, NH 1926. Number 3, non-mandatory powers contrasted with trust. Section 201. A power that is not imperative, i.e., is not fiduciary in character, but may be exercised or not entirely at the will of the power holder, the donee of the power, is not a trust and does not require definite beneficiaries. This is a power that with respect to which the transferor did not intend to impose a duty is generally valid as a power, i.e. as a power of appointment. See future interest summary, regardless of whether the permissible appointees are 1, unlimited so as to include the power holder, a general power, 2, limited to a definite class, a special power, or 3, limited to an indefinite class that does not include the power holder, perhaps a broad, non-general, or hybrid power. Example, testator's holographic handwritten will bequeaths, quote, such of my jewelry and household goods as sister may designate to such of my friends and relatives as sister may select, but sister has no obligation to do so, and if or so far as sister does not do so, such properties shall be a part of my residuary estate, which I bequeath in equal shares to my children who survive me, and if none do, then to charity. Sister has a power to appoint, but no trust is created. If sister exercises the power, the exercise will be given effect to the intent the appointee reasonably fit within the above quoted description, i.e. do not exceed the scope of the power. If sister does not exercise the power, the property passes in default of appointment, in this case, as a part of the residue of testator's estate. A, powers in connection with trust, Section 202. Although a power as such is not a trust, powers, whether fiduciary, such as discretionary powers or powers of appointment, are typically created in connection with trust, i.e., as just one of the many provisions of a complete trust. Often, a life beneficiary will be given an inter vivos or testamentary power of appointment. That's what I was just saying. Example, transferor bequeaths to transfer in trust to pay the net income to niece for life and on niece's death to distribute the principal to nephew if living or to nephew's issues per stripes, provided, however, that during niece's lifetime, transferee shall distribute such amounts of income and principal, if any, as niece may appoint to any one or more or none of my friends, Andy, Beth, and Carl, as niece may designate. There is a trust. End quote. There is a trust. Niece also has the power of appointment. Here, the objects of power potential appointees are definite, but they need not have been. Example, transferor bequeaths, quote, to transferee in trust for niece for life, and on niece death, transferee shall distribute the principal to such one or more of niece's issues, and in such shares as niece may designate, and if niece does not so designate, transferee shall distribute the principal to niece's issues per stirps. Niece's end quote. Niece's power is not itself a trust, but it is one of the provisions of a trust. Number 4, power does not require definite class, section 203. Although the power of appointment in the preceding examples are exercisable in favor of a definite group, Andy, Beth, and Carl, or class, niece's issue, the group need not have been definite because the powers are not imperative, such as niece could have had a valid testamentary power to appoint by will to anyone at all, including her estate, or to anyone other than her estate or her creditors, as is common for tax reason. The distinction between powers of appointment and fiduciary powers of selection is explained in the third restatement, section 46, comment C. According to the traditional law of trust, if the transferor had intended to create an imperative power, i.e., a fiduciary duty to act, or at least to consider acting, that was to constitute a trust purpose and was to determine who benefits from the trust, the class would have to be a definite one, so that there would be definite beneficiaries to enforce the trust and among whom distribution, if necessary, could reasonably be made equally or per stirps by a court if the trustee or trustees improperly failed or refused to act. If, as is usually the case, the power represented only one of the trust purposes and was not expected to exhaust all of the trust property, the court would replace the trustee who had abused her discretion. Exam tip. Remember that as long as the class is reasonably definite, the trust may authorize the trustee to exercise his discretion in selecting members to be benefited, or may provide that only those who meet certain requirements will benefit. Broad power to choose beneficiaries, however, may constitute a power of appointment rather than a trust. What constitutes a reasonably definite class? Section 204. For there to be a trust, the class of beneficiaries must be definite enough that a court can determine, one, by whom or on whose behalf the trust may be enforced. Any member of a definite class of beneficiaries of permissible discretionary beneficiaries. One moment, please. I'm going to start over. What constitutes a reasonably definite class? Section 204. For there to be a trust, the class of beneficiaries must be definite enough that a court can determine, 1, by whom or whose behalf the trust may be enforced. Any member of a definite class of beneficiaries or of permissible discretionary beneficiaries may bring suit. And 2, where the trustee has a power of selection, whether the selection is within the authorized class, or if no selection is made, to whom distribution is to be made by distribution to all or some members on some principle, such as that of representation. But see Restatement 3D, 46, number 2. Intended trust that requires trustee to select from indefinite class, and thus no enforceable duty, treated as a trust with a non-mandatory power, i.e. no duty to distribute, with reversion to extend unexercised. In the case of an intended power to appoint, the court need only be able, as a matter of interpretation in the event of a challenge, to determine whether an appointee fits within the class terminology used. Thus, the entire class need not be definite, such as my friends. Even in these cases, however, the same concept of definiteness may have some relevance. If there is no provision stating who is to take in default of appointment in court, a court will usually imply that the takers in default are members of the class, all taking equally or perhaps some taking per stirps. If the class is definite, but will not so imply if the class is indefinite, so that there will usually be a resulting trust. Number 1, definite, section 205. Most clearly, the following class gift terms describe a sufficiently definite class to serve as a class of trust beneficiaries or as implied takers in default: children, brothers and sisters, nieces and nephews, heirs or next of kin, and issue or descendants. Cousins is all right, provided the court will determine the degree as a matter of construction, meaning only first cousins. Indefinite, section 206. At the other extreme, the following references are not sufficiently definite to constitute a definite class. 1, to such persons as my trustee may select, end quote. 2, quote, among such of my friends as the trustee shall determine, end quote. And 3, in the absence of a formula or reasonably objective criteria, quote, to such persons as my trustee deems most appropriate, end quote. Number 3, location, section 207. Quote, all those who reside or work at the same address as the settler during his lifetime has been held to constitute a sufficiently definite class. In Ray Gulbenkian's Settlement Trust, 1968, remaining uncertainties can then be unresolved by interpretation. Number 4, family, section 208. Family is not without potential difficulty, but is generally so construed as to constitute a sufficient definite class consisting of one's spouse and children, and probably other persons living with the person whose family is designated in what is generally understood as a family relationship, thus leaving further room for interpretation, which courts are likely to be willing to understand or undertake as necessary, such as to determine specific questions about inclusion of stepchildren, etc. Restatement 3D, section 45, CMT-E. Number 5, relatives, etc., section 209. Relatives, relations, kindred, and the like, family more broadly construed than above, present a more troublesome problem upon which the authorities differ as the terms may be considered too vague. How many degrees of relationship are intended to be included? Second, third, or sixth cousins? First cousins twice removed, aunts and uncles, great aunts and uncles, great grandnephews, descendants, or collaterals who have living ancestors between themselves and the transferor. A first step again is to decide whether to accept the class as definite. If a court decides to do so, it will undertake the task, inevitably involving guesswork of clarifying the settler's definite but carelessly vague class language. A. All relatives, indefinite, section 210. If it is clear that the transferor meant all relatives, however remote, and intended trust would fail, an intended trust would fail for indefiniteness of beneficiaries under the general rule, and this has traditionally been so, even though a power of selection has been given to the intended trustees. Dalton versus White, 1942. But see Restatement 3D, Section 46-2, Power but no duty, UTC Section 402. C. B. Modern construction, next of kin. Many and probably most courts today, however, will attempt to uphold the gift by interpreting relatives and the like to mean those who are designated persons next of kin in existence at the relevant time, usually the time when the trust takes effect. And this would then constitute a sufficiently definite class of beneficiaries or discretionary beneficiaries to sustain a trust. Restatement 3D 45 CMTD. C. Trustees and court selections compared. Section 212. In a transfer upon trust for, quote, such of my relatives as the trust may select or the trustee may select, end quote, most courts apparently would sustain the trustee's designation of any relatives, i.e. generally any blood relatives, but that too is a question of construction and may well be narrowed or broadened somewhat by a supervising court, without limiting the recipient to next of kin. In Ray Polton Will Trust, 1987. But if the court has to make distribution because the trustee fails or refuses to do so, then the property goes to the next of kin. In Ray Rowland's estate, Arizona, 1952. This may seem incongruous, but courts apparently seek not to restrict the trustee's freedom of selection while at the same time seeking to uphold the intended trust rather than have a resulting trust arise. This same analysis is used when a power holder who has a power to appoint among an analogous class fails to do so, and the question arises whether and how a gift is in default of appointment may be implied. Definite versus indefinite class terms. Sufficiently definite, not sufficiently indefinite. So you have children, issues or descendants, heirs or next of kin, brothers and sisters, nieces and nephews, cousins, if only includes first cousins, and such persons at location are sufficiently definite. Then you have in the middle, family, relatives, and kindred. So that can be weighed either way. Then you have not sufficiently definite class terms, such as my friends, such persons as trustee may select, and such persons as trustee deems appropriate. Those are indefinite or sufficient or not sufficient definites. Number 6, failure of trust for lack of definite beneficiaries, analysts, authorities, and review. A, power, section 213. Non-imperative. A non-imperative, more properly, non-fiduciary power not intended to be a trust is valid without definite beneficiaries because there is no need to enforce trust duties and no need, although if the class is definite, there may be opportunity for a court to make distribution upon failure to exercise the power. On this, the authorities are in agreement, and there is no frustration of a transferor's purpose to cause concern. B. Trust with definite beneficiaries. Section 214. A trust is valid where it is for the benefit of a definite class of beneficiaries or for such of them as the trustee selects. In both of these types of situations, it is clear that any member of the class may bring suit to prevent a trustee from absconding with or misapplying the property, or to surcharge, mismanagement, or otherwise correct a breach of duty. The court also knows what to do, if need be, to implement the trust. On this, too, the authorities are in agreement, and there is no frustration of the settler's purpose. C. Trust with definite beneficiaries or without definite beneficiaries. The traditional American doctrine is that an intended trust fails where there is no beneficiaries other than the members of an indefinite class, and a discretionary power in the intended trustee to select from among such an indefinite class will not save the intended trust. The reported cases are almost always of this latter variety involving discretionary selection. The courts say that if there were to be a trust, there would be one to enforce it, and no reasonable way for the court to carry it out if the trustee did not. Therefore, it is said to follow that there is no express trust, nor is the intended trust to be treated as a power, and such allowed. There is merely a resulting trust. These dubious but traditional assertions about inability to enforce and execute a trust here, together with the unnecessary frustration of the transferor's intended purpose, lead the dissatisfaction with, and so far growing but modest dissent in case law from this generally held position of trust law. G. Palmer, Private Trust for Indefinite Beneficiaries, 71 Michigan Law Review, 359, 1972. Example, an illustration both of a classic problem and of the traditional result under the clearly predominant line of case law is the failure of an intended trust for such persons, societies, and institutions as the fiduciary may consider most deserving. Nichols versus Allen, 130 Massachusetts, 211, 1881. Example. Another classic example is one that in many American states today would come out differently, not because of a different view of the definiteness of beneficiaries requirement, but because of the likelihood of a favorable construction that would limit the purposes to charitable ones. The bequest to the bishop in trust, quote, to dispose of the property to such objects of benevolence and liberality, end quote, as he, quote, shall most approve of, end quote, failed for indefiniteness in a leading case in England in 1805. Bishop was ready to carry out the purposes, but was not allowed to do so, as the trust failed and the property belonged by resulting trust to testatrixes, next of kin. 1. Contrary view, intended trust treated as a power. Section 216. A modest minority of American cases are contrary. Feinberg versus Feinberg, 1957, as is the view of the second restatement, reversing the position of the first restatement. Restatement 2D, section 123, and restatement 3D, section 46-2, more more structured view. See California Probate Code 15205B2 and UTC Section 402C. England's view is also changing. N. Ray Badden's Deed Trust, 1971. AC 424, J. Hopkins, Certain Uncertainties of Trusts and Powers, 29 Chamber LJ 68, 1971. But C. N. Ray Beatty's Will Trust, 1990. This view, as long ago argued by Amos, would treat the intended trustee or trust simply as a power in order to allow the intended trustee, if willing, to carry out the purpose within a reasonable time, if not in fact carried out by the power holder, and even for enforcement purposes in the meantime. This view would treat the situation as if it were a trust for the very beneficiaries who would have taken by a resulting trust, with their interests being subject to divestment by the exercise of the power, clearly an arrangement which, if expressly created, could be carried out. The failure of the Tendon Trust, 1892. E. Nature of the beneficiary's interest, Section 217. While early cases disagreed as to whether the beneficiary had a mere personal claim against the trustee, an equitable estate in the trust res, or both, modern law generally recognizes the beneficiary as the equitable owner of the trust res, as well as the holder of equitable rights of specific enforcement against the trustee to have the trust carried out. Restatement 3D, Section 2, Part 4, Introductory Note. Thus, if the trust involves real property, the beneficiary is deemed to have a real property interest, i.e., an equitable estate in land itself. Minority View, Section 218. In New York and a few other states, the law is or appears contra by statute. The beneficiary has no interest in the property, but only personal rights of enforcement against the trustee. Thus, in Marks versus McGlynn, 88 New York 357, 1882, decided under the New York statute, the court held that it did not violate an alien land law for an alien to be the beneficiary of a trust of real property because the alien had no interest in the land itself. Even in states that have or had statutes like the New York statute, the legislation may not be given like effect. For example, would a court really treat beneficiaries as general creditors who share trust assets with the insolvent trustees, general creditors? But see Section 106. When it matters, courts have generally recognized under such early statutes that the beneficiary's interest as one of the equitable ownerships of the property itself. Title, Insurance and Trust Company versus Duffield, 1923. Number 2, Incidence of Beneficiary's Interest, Section 219. Various characteristics, treatment, and court discussions of the interests of trust beneficiaries tend to support their characterization and as equitable interest in the property. For example, a beneficiary's interest may be assignable voluntarily or reachable by creditors, or it may be protected by valid restraints on alienation. See Infra Section 441 et sec. Number 3, Equitable Conversion Doctrine, Section 220. The terms of the trust can affect the nature of the beneficiary's interest. Thus, in a trust of realty where the trustee is required to sell the land and hold the proceeds in trust, the beneficiary often is deemed not to have an interest in the land, but an interest in personally in the sale proceeds. The beneficiary's interest is said to be equally converted from real to personal property. Hitchens versus Safe Deposit and Trust Company, 1949. A. Notes. Conversely, if the trustee is required to invest trust funds in the purchase of real property, the beneficiary's interest may be regarded as a real property interest even before the purchase is made. Restatement 3D, Part 4, Introductory Note. Exam tip. Whether a beneficiary holds equitable title in real property or personal property may be important where the beneficiary dies, leaving her real estate to X and personal property to Y, or where different substantive or procedural rules apply to realty and personality, even if by antiquated concepts such as at common law, real property descended to the descendants or the decedent's heirs, while personal property was distributed to the decedent's next of kin. See Will's summary. Parties to a trust, a review. Okay, so on this table, you have the settler, you have a testamentary trust, you have the donative inter vivos trust, and then below that you have trustees and beneficiaries. On the top side of the table, you have required capacity, and you have the rights in trust res, and you have can creditors reach interest. So for settlers, the required capacity depends on type of trust. If it's a testamentary trust, the settler must be a legal age and sound mind, know the nature of her act and extent of her property, and who are naturally and who are the natural objects of the bounty of her bounty, i.e. testamentary capacity. For a donative inter vivos trust, the settler needs to have the ability to understand impact of transfer upon financial security. So the settler will give the duties to the trustee. The trustee's duties must be able to one, take and hold title and administer the trust. And note, minors and disabled persons meet one but not two. So a minor will meet the one qualification, but not the second. They can't administer the trust, but they can hold and take title. Beneficiaries must be able to take and hold title. They have equitable title. The trustee has legal title. And beneficiaries, it says, can creditors reach interest of beneficiaries? It says yes, unless protected by a spendthrift provision. See Infra Section 41. Can a creditor reach the interest of a trustee? It says no, because they only have legal title. They only have legal title, not equitable title. Okay. And then can creditors reach interest of a settler? It says yes. Okay. This is good stuff, you guys. Very good information is being broken down here for us to be able to understand and understand this concept of trust and how it works. So make sure you guys are hitting that like button and put some comments in the comment section as well. I definitely will respond back to you. I like to interact with you all outside of, these readings or whatever. And if you'd like to join the community, just feel free to email me at my email. You can find all of my contact information in the description area of the video. Also, if you'd like to make a donation, just to, be, show your gratitude, then you can do that as well through Cash App or through my Chime. And that information can also be found in the description area of the video. Okay, so we are going to continue on reading. It says number 4, the extent of interest, section 221. The beneficiary's equitable interest under the trust may be for years or for life. It may be an interest of indefinite duration, or it may be a future interest. It may be contingent or vested, subject to a condition precedent or subsequent or determinable. And it may be possessory or non-possessory. Furthermore, the settlor may make some beneficiaries primary or preferred cestuous and others only secondary. Number 5, form of co-tenancy, Section 222. Whereas co-trustees are presumed to hold as joint tenants with right of survivorship, see Super Section 148, co-beneficiaries of internet and rest are presumed to acquire and hold the interest as tenants in common unless the settlor has expressed another intent. Thus, on the beneficiary's death, any remaining interest she has in the trust passes to her testate or intestate successors. It does not belong to the other beneficiaries unless the trust expressly or impliedly so provides. So, trust purposes. 1, requirement of lawful and appropriate purpose. Section 223. A trust may not be created for a purpose that is illegal or contrary to public policy. Statutes in some states provide that a trust may be created for any purposes for which a contract could be made, but it is not at all clear that these statutes alter the purposes allowed or prohibited by the general common law of trust. A private trust, Section 224. Usually the objective of the settlor is to promote or secure the welfare of some person or limited number of people, spouse, children, family, etc. This is, of course, a permissible private trust purpose. In fact, it is increasingly accepted that a private trust its terms and its administration must be for the benefit of its beneficiaries. Restatement 3D, Sections 27 and 2, and see UTC Section 404. B, charitable trust, Section 225. Where the settlor's objective is to promote the welfare of members of a large and indefinite group of individuals, i.e., or such as students at a particular school through a scholarship fund, or of the public at large, the trust purpose may be considered sufficiently important such that special rules apply to the trust as one having a charitable purpose. See Infra Section 502 et sec. Honorary and mixed trust. See Section 226. Except for the special case of purpose trust or honorary trust, see Super Section 170. A trust must either be private or charitable, or if the interests are separable, it may be partly each. Restatement 3D 28 CMTE. However, a transfer that does not create a private trust generally cannot establish a trust for purpose that does not or that do not qualify as charitable. William F. Fratcher, Bequest for Purposes, 56 Iowa, Law Review 773, 1971, but see Restatement 3D, Section 47, encouraging a somewhat liberalized set of rules and concepts for purpose or honorary trust. Number 2, impermissible trust purposes. Occasionally, a trust, or more often some provisions therein, may be challenged as invalid if it appears that the settlor was attempting to accomplish an objective that is illegal, requires the commission of a criminal or tortious act by the trustee, or would otherwise be contrary to public policy. Restatement 3D, Section 29. A, fraud on creditors. An example of an invalid trust purpose is where the owner of property transfers it to another in trust for the transferor for the purpose of concealing the property to hinder or defraud the transferor's creditors. 1. Effect. In this situation, the trust is regarded as a nullity, and the creditors of the settlor may reach the property as if the trust did not exist or set aside the transfer as fraudulent. Compare under a somewhat similar but different principle a transfer in trust, like an outright transfer may be a quote fraudulent conveyance, even though it is not otherwise a nullity or illusory, i.e., even though it is generally for the benefit of others, such as the settler's family. If the transfer is not for adequate consideration, and if the transferor is or is thereby rendered insolvent, or if the transfer it was made with intent to hinder or defraud the transferor's creditors. Number 2, can settlor regain property? Section 229. Suppose no creditors materialize or that the transferor was able or forced to pay his creditors out of other funds. Will he be permitted to compel the transferee to return the property? A. Some cases hold that he cannot. His purpose may be considered to be so improper that he is not entitled to relief in equity, unclean hands, as equity will not leave wrongdoers. As equity will leave wrongdoers where it finds them. The express trust will not be enforced and no constructive or resulting trust imposed under such a rule. Even a dishonest transferee may be allowed to retain the property. McRae versus McRae, 1930, Arizona. Tatum versus Miller, 1858. B, other cases hold that the determinative factor is whether the intended fraud actually succeeded or involved serious moral turpitude. If no one has been hurt, and especially if the offense to policy is not serious, a court may order the return of the property to the transferor to prevent unjust enrichment of the transferee. Bernecker versus Bernecker, 1947, Restatement 3, Section 8, CMTI. Distinguish protection of beneficiaries' interests. Section 230, while the settlor cannot employ the trust device to avoid his own creditors, he can employ it to shelter the interest from the beneficiary's creditors. See Infra Section 460 through 489. B, other prohibited trust purposes, Section 231. Other trust purposes or conditions that are invalid as being contrary to public policy include trust or provisions for capricious purposes, such as to destroy or waste valuable property, or that reward a person for committing an act that is immoral, illegal, or contrary to the perceivable public interest. Significant examples of trust purposes that are against public policy are: 1. Restraints on marriage. Section 232. Trusts that unreasonably restrain marriage by a beneficiary are invalid. Reasonableness turns on the duration and extent or breach of the restraint. Thus, a gift in trust for daughter as long as she remains single but if she ever marries to son would be unreasonable, whereas a restraint on marriage until age 21 is likely to be upheld. A gift over on the remarriage of the settler's surviving spouse. Income for the life of my spouse, wife, but if wife remarries, the trust shall terminate and be distributed to my issue. Is by nearly all in cases, some statutes, not reasonable, apparently because a settlor may provide for his spouse during her widowhood. Number 2, encouragement of divorce. Trusts that encourage a beneficiary to divorce are also invalid. However, in most cases, or in most states, if the gift merely attempts to provide for the beneficiary in the event of divorce rather than inducing divorce, it is valid. Parallel evidence of the settlor's subjective motive is admissible to determine validity. See Yiser versus Rogers, New Jersey, 1955. Critics of this distinction point out the potential for manipulative drafting, the speculative or unreliable nature of such evidence, and that effect, not motive, should matter. A. Distinguish discouraging divorce, Section 234. Because public policy is said to favor marriage, courts have upheld conditions requiring that a beneficiary cannot divorce a spouse. In Ray Estate of Heller, Wisconsin, 1968. Distinguish will provision, Section 235. A will provision that is conditioned on the beneficiaries being divorced or not having remarried when the testator dies is normally invalid. This is because there is no continuing inducement in their will, and there would be if a trustee were used. There is no continuing inducement as there would be if a trustee were used. The testator is generally considered to be free to leave or not leave property to a beneficiary for whatever reason the testator sees fit, but a person is not allowed to use a trust for all purposes that would have been permissible to that person during life or directly by will. Trusts, whether testamentary or irrevocably inter vivos, are seen as imposing a burden on others and insufficient and inefficiency on society, and therefore worthwhile private or charitable purposes are required. Thus, reasonable regulation of dead hand control has long been recognized as appropriately limiting freedom of testation, and like principles apply to revocable living trusts. Exam tip. If you encounter an exam question in which a beneficiary's interest is conditioned on his marital status, like at the settler's intent, if the purpose of the restraint is to penalize marriage or encourage divorce, the restraint may be struck down. On the other hand, if the purpose is to give support until marriage or during divorce, the restraint is likely valid. Number 3, interference with other family relations. Section 236. Cases have invalidated conditions that tend to disrupt other family relationships or to discourage resumption of family interaction. Example, Joseph Romero divides his residence to his sons, Joseph Jr. and Frank, quote, so long as they want to live at the residence, provided their mother does not reside there also. If Joseph's primary intent was to separate his sons from their mother, the provisions are violative of public policy and should be stricken. See Infra In Re Estate of Romero, 1933. New Mexico, 1993. Example, J.E. Bobo divides the residue of his estate to Republic Bank and Trust to pay the income of his surviving wife. To pay the income to his surviving wife, Mildred, for her life, and upon her death to divide the trust into 2 trusts, the Margaret Stewart Trust for her daughter, Margaret, and Mildred Ramirez Children Trust for his grandchildren, Margaret's nieces. Subsequently, Bobo executed a codicil that provided if either Robert or Marjorie Kirby are named and appointed as guardian of any of the beneficiaries taken under the same Mildred Ramirez Children Trust, all funds and all property held in trust for said beneficiary shall revert and become a part of the Margaret Stewart Trust. The condition is void against public policy. Stewart versus Republic Bank, Dallas, Davis, National NA, 1985. That was quite a story. Religious restrictions. Religious restrictions on religion come under the close scrutiny by the case law on this matter. Restrictions on religion come under close scrutiny, but the case law on this matter is neither consistent nor clear. Such conditions are sometimes upheld and sometimes not. See Lynch versus Uhlenhop, Iowa, 1956, declaring as void condition that child whose custody was awarded to wife shall be reared in the Roman Catholic religion. United States. National Bank versus Snodgrass, 1954, upholding conditions that beneficiary prove she had not before age 32 embraced a particular religious faith or married a man of that faith. Number 5, third restatement view, section 238. The third restatement would invalidate any condition that tends to seriously influence important personal decisions and interlude on the lives of beneficiaries or others, as in Ray Estate of Heller, Supra, Restatement 3D, Section 29. It also suggests reformation, i.e., revising the terms to minimize the intrusion. In such cases, to accommodate any legitimate trust-related concerns rather than allowing findings of acceptable motivations to sustain conditions that would otherwise be objectionable. 1994. C. Effective invalid provisions, Section 239. The consequences depend on the settler's probable intent, as expressed in the trust instrument or as otherwise gleaned by the court. The court's response is not a punitive one. Usually, courts will attempt to excise the illegal purpose or condition and enforce the trust without it, so long as it does not defeat the overall purpose of the settler in creating the trust. Restatement 3D, Section 29 CMTI 1. A substitute gift may have not been given effect, however, if a court deems it impermissibly deters a challenge to an objectionable provision, such as racial restriction in a charitable trust. Home for Incurables versus University of Maryland Medical System, 2002. Example, settler bequeaths money to trustee bank in the trust to pay the income to husband, quote, provided husband divorces his wife, quote, because the condition appears to be aimed at procuring a divorce, it is invalid. Husband is therefore entitled to the income free of the condition unless the circumstances indicate that settler would not otherwise have intended husband to have the income at all, i.e., either based on a court's interpretation. Husband receives the interest unconditionally at the outset, or he does not receive it at all, regardless of the divorce. Number 1, rational. Nothing can turn on the valid condition which is stricken. The choice the court makes depends on its assessment of probable intent, usually with a preference for allowing the benefit unconditionally. Courts sometimes suggest that it matters whether the intended condition is precedent or subsequent, but this is dubious and of little relevance anyway, if probable intention is supposed to control. See Supra, Section 238. Number 3, related question of permissible duration, Section 240. The law is concerned about the period of time during which the dead hand may tie up property in such way as to restrict or impair the freedom of those currently beneficially interested in it. The trust is the principal device through which property is tied up in ways that affect this freedom, and the laws have developed a variety of rules for dealing with problems of this general type, i.e., for reconciling the competing values, such as a free testation for the prior owners versus free of efficient use by current owners. In this area of issues, By virtue of these rules, private trusts and sometimes particularly charitable trusts that are designed to last indefinitely or that prevent beneficiaries' interests from being ascertainable, or more specifically from vesting for an unduly long time, will run afoul of various rules of property law. Rules against perpetuities 241. The most sufficient rule in this area in most states today is the so-called common law rule against perpetuities, a rule against excessive remotiveness of vesting. The rule was developed at common law and exists usually in modified forms. See Infra Section 244. In most states today, although some have recently abolished the rule. Number 1, Statement of Traditional Rule, Section 242. For an interest to be valid, it must vest, if at all, no later than 21 years after some life in being at the creation of the interest. John Chipman Gray, The Rule Against Perpetuity, Section 201, stated conversely, an interest is void at the outset of it, judged at that time, there is any possibility that the interest, as worded and without regard to the rule, might vest later than the perpetuities period of a life or lives in being at the time of the transfer, plus 21 years. See Future Interest Summary and see Restatement 3D, Section 29B. Number 2, Explanation and Scope of Rule. The traditional rule applies to non-vested future interests. At the moment of creation, the interest must be absolutely certain, either to vest or to fail within the permitted period. Otherwise, the interest is destroyed. The rule applies to both real and personal property and to equitable as well as interest. It invalidates offending beneficial interest in a trust, even though the trustee has power in a fiduciary capacity to sell the trust assets. Number 3, requirements of vesting and certainty. Section 244. The traditional rule requires only that the future interest will certainly vest in interest or fail within the period. It need not entitle the owner to immediate possession or payment of trust income or principal. As traditionally viewed, the common law rule insists upon absolute certainty from the outset, with no wait and see opportunity. This view of the common law was rejected in 1983 by the American Law Institution, or Institute Ali, which has now adopted the wait and see approach as the preferred view. Restatement 2D of Property 1.4. Wait and see legislation also exists in a number of states. If the common law rule is not satisfied, an alternative 90-year waiting period is allowed by the Uniform Statutory Rule Against Perpetuities, USRAP, promulgated in 1986 by the National Conference of Commissioners on Uniform State Laws and enacted in a growing number of states. See also Infra Section 251. Example, all interests are valid in a device. Quote, to my children for life, remainder in equal shares to my grandchildren for their respective lives, and on the death of each, the remainder of his and her shares to friend. The trust may endure beyond the period, but this is not right because all interests will necessarily have vested, and the amounts of their shares will be known by the death of the testator's last surviving child, who is necessarily a life in being at the testator's death, even if the child is a gestation, although modern reproductive techniques were not contemplated by the common law. At that time, the grandchildren's secondary life estates will vest, while friends' remainder, although not possessory vested, i.e. was in an ascertained person, free of conditions, precedent as the testator's death. Example, administrative contingencies. Testator devises her estate, quote, to my issue who are living to my issue who are living when administration of my estate is complete, end quote. Under normal construction, the interest intended for the issue is invalid because it is possible, although barely conceivable, that estate administration will continue beyond the period of the rule. Similarly, a trust for my issue until my plan for development of Green Acre is completed and then to be terminated with distribution to my living issue is invalid at common law. Thus, some instances of excessive delay in vesting involve innocent looking interests or trusts that do not realistically involve dispositions of intended duration. Compare if in the above examples, respectively, the device at completion of administration is, quote, to my husband if then living, and if not, then to my children in equal shares, end quote. And the trust is for a friend with distribution to her on development projects completion. All interests are valid. Despite the potentially excessive delays in the latter situation, friend's interest is vested at the outset. In the former, the interest of husband and the children are all certain either to vest or to fail by the time of husband's death. And furthermore, the children could serve as lives in being, even if they have been expressly or as would be unlikely, impliedly required to survive until administration ended. Exam tip. In analyzing rule against perpetuities problem, in the absence of a statute, such as wait and see or USRAP, keep in mind that the key is when the interest could apply or could possibly vest, not when it is likely to vest or even when it did. You must examine the grant as to the time of its creation and be sure that if the interest vests, it will be within the period of the rule, i.e. a life in being plus 21 years. If there is any possibility, no matter how absurd, that the interest could vest beyond the period, it is void. Interest subject to rule, section 245. The technical formalistic nature of vesting traditionally requires one to distinguish between conditions precedent and conditions subsequent, and also between remainders and executory interests, as executory interests do not vest until they come into possession, but all possibilities of reverter and rights of entry are immune to the rule. See Property Summary. Exam tip. Although the rule against perpetuities is one of the most feared and confusing rules of law you will ever encounter, there are some simple rules to help you apply it. One is that the rule applies to contingent remainders and executory interests. When you see either of these on your exam, think about the rule. On the other hand, you don't need to consider any of the grantor's interests, reversions, possibilities of reverter, rights of entry, as they are immune from the rule. Example, B, class gifts, section 246. Also for technical reasons in general, but subject to some exceptions. An entire class gift is void if the interest of any single class member may vest beyond the period, i.e. all class members generally stand or fall together. Example, grantor deeds to grantee for life remainder equally, quote, to those of my children who attain age 50, end quote. The remainder is void even with respect to the intended interests of grandchildren who are already alive at the time of the transfer and whose rights would therefore necessarily either vest or fail within their own lifetimes because the potential interests of afterborn grandchildren upset everything. Note, 1. Under the restatement rule, there would be no violation unless the interest of an actual afterborn grandchild in fact violates the perpetuities period. Also compare US Rep's 90-year alternative supra. Number 4, partial exceptions for charities. Section 247. Property rights may validly shift from one charity to another beyond the period, i.e., property need only become vested in charity, and such a charitable trust may endure forever. But a possible shift beyond the period from a private to a charitable purpose or vice versa is not permitted, and the interest that is to take effect on the exclusive remote contingency fails. Exam tip. The charity to charity exception to the rule against perpetuities comes up occasionally on exams. The important point to remember is that the exception applies only if the gift shifts from one charity to another. If the gift shifts from a private to a charitable use or from a charitable to a private use, the rule applies and you must consider whether the interest is valid. Number 5, perpetuities period, section 248. The perpetuities period is lives in being and 21 years, measured from the time the interest is created. When the testator dies, if by will or when an inter vivos trust becomes irrevocable. A, gestation period, section 249. The period is extended to encompass actual periods of gestation so that a child conceived at the time of the transfer is a life in being, see example supra section 244, and one conceived at the end of the measuring lives is allowed the remaining gestation period plus 21 years for her interest to vest. B, who is a life in being, section 250. One may serve as a measuring life without being either a beneficiary of the disposition or designated in the instrument, although designated measuring lives must be reasonable in number and difficulty of ascertainment. The period begins to run, and therefore the measuring life must be one who is in being at the date of the testator's death or at the date the inter vivos transfer becomes irrevocable. Although strictly speaking, any life in being is technically eligible to serve. As a practical matter, the only ones that are actually relevant, i.e. useful, are those that bear some casual relationship to the eventual vesting of the interest in question. Again, this traditional view is to be contrasted with the wait and see rule, Restatement 2D of Property 1.4. And the 90-year alternative of USRAP or USRAP. Example, testator's bequest, quote, to such of my grandchildren as attain age 21, end quote, is valid because testator's children will necessarily be alive or in gestation at testator's death and are relevant to vesting and thus are useful in measuring lives, and that no grandchild's interest can possibly vest more than 21 years and an actual gestation period after the last surviving child's death. Example, if the above remainder had been 1, by irrevocable inter vivos transfer, or 2, bequeathed to grandchildren who reached age 25 under the traditional rule, it would fail because in the first scenario of all the transferors' children are not necessary in being. The critical last surviving child could be afterborn, generally without regard to the transfer's age, sex, and physical condition. And in the second scenario, an afterborn grandchild might be less than 4 years old when the last child dies, i.e. the last relevant measuring life ends. Note, There would be no invalidity in 2 if no child survived the testator, might making the grandchildren themselves a class of lives and being. Okay. I'm gonna take a pause for some water. Okay, continuing on, number 6, effect of remoteness, section 251. The rule in its traditional form strikes down the offending interest. The trust and the other interests are carried out without it. Unless under the doctrine of infectious invalidity, to do so would defeat the unnecessary distort the settler's purpose. A sufficient number of statutes, including those based on USRAP and the current alley view of the common law, call for reformation to approximate the settler's intention within the perpetuities period, rather than destruction of the offending interest. Restatement 2D of property, section 1.5. B, statutory rule against suspension of power of alienation, section 252. There was some early uncertainty as to the real nature of the rule against perpetuities. Most authorities viewed it as a prohibition against the remote vesting of estates, and this became the common law rule, see Supra, section 242. Others, however, had contended that it was a prohibition against limitations that had the effect of tying up land and making it inalienable for too long. The later interpretation viewed the appropriate rule as one against suspension of the power of alienation, and some states enacted legislation in place of or in addition to the common law rule, now most repealed or modified, usually to return the common law period of time. Under such rule, based on early New York legislation, an interest would be held void if, by virtue of any restraint or contingency, the absolute power of beneficiaries to transfer the complete and full ownership was lacking for longer than the allowable period. Note, ordinarily, a transfer that violates the rule against perpetuities also violates the rules against suspension of the power of alienation. But there are some situations in which a conveyance that is not in violation of the former may nevertheless violate the latter. See future interest summary. Number C, rule against accumulations, section 253. Another rule was developed at common law to prohibit provisions for unreasonable accumulation of trust income. Usually concerned with accumulations in private trust beyond a period of lives and being plus 21 years, the law of the state differs in this area and are often unsettled. The rule in many states evolved from dictum to, in the case of Thullison versus Wolford, 1805, and was later embodied into a statute known as the Thullison Act. Example, in a transfer, quote, to trustees in trust for a son for life, remainder to daughter, provided that the trust shall continue and no distributions of income or principal shall be made until the properties are sold and the trust corpus is reduced to cash. The restrictions on distribution may be held void because it is not certain to expire within the permissible period, for one cannot be sure when the sale will occur. Number 1, charitable trust. Section 254. Like the rules against perpetuities above, This general rule against accumulation is not applied to accumulations in a wholly charitable trust. Holding versus Rattery, 1961. But some states may hold simply that in such trusts, provisions for accumulation must be reasonable in amount and duration. D, trust may continue beyond perpetuities periods. 255. Trusts are sometimes created to last beyond the period measured by a life or lives in being, or even potentially for an indefinite period of time. Thus, a testamentary in being, or even potentially for an indefinite period of, thus a testamentary trust to pay its income to my children, and thereafter to pay the income in equal shares to my grandchildren, indefinitely or forever, and thus in effect to the successors and interests of the respective grandchildren, is valid because all the grandchildren will be ascertained and their interests will vest by the death of the last of the testator's children, who are all lives in being. Number 1, common law, section 256. At common law, there is no general objection based simply on the trust duration. In theory, at least, there can be perpetual trust for private purposes as long as all interests have properly vested within the period of the rule. Nevertheless, the duration of the trust may cause some problems if it is to last beyond the permissible period. Result number 2, trust valid but altered, section 257, by case, decision, and sometimes reaffirmed by statute. Such trusts are valid and may continue beyond the perpetuities period, but once the perpetuities period has expired, A, the trust is not and no longer can be indestructible, i.e. all beneficiaries can join to terminate it despite the Claflin Doctrine, Infra Section 954. See California Probate Code Section 15403 and 15407. Trust may be determined upon expiration of the permissible period by court decree or perhaps on request of the majority of the beneficiaries. In re shall crosses estate, 1901. And B, any restraints on alienation, such as a spendthrift clause, see Infra Section 460, and powers over benefits, such as power of appointment, unless equivalent to complete ownership, such as a presently exercisable general power or trustee discretion over distribution, cease. Private, charitable, and honorary trust compared. All right, so you have characteristics in this column, private trust in this column, charitable trust in this column, and honorary trust in this column. So we're trying to find out the characteristics of each trust, and the characteristics of the characteristics of those intents or purposes of the trust. So enforceable beneficiaries, purpose, and rules against perpetuities. So it says for a private trust, it is enforceable, yes, by Attorney General, and no, it says, okay, I'm sorry. A private trust is enforceable. A charitable trust is enforceable by an Attorney General, and an honorary trust is not, but trustee may choose to perform. Okay, so beneficiaries, for private trust, one or more identifiable beneficiaries ascertainable within the rules against perpetuities. Any legal purpose against public policy applies. For charitable trust, indefinite beneficiaries, charitable purpose only, and the rules against perpetuities doesn't apply. For honorary trust, it is not enforceable again, and it doesn't need to have no beneficiaries capable of enforcing, but it says the purpose neither charitable nor private for care of a pet. And it says the rule of perpetuities, it applies in the absence of contrary legislation. Okay. So that is the end of this chapter, you guys. I hope you guys enjoyed the read. I will be back tomorrow for picking up on chapter 3. Okay, chapter 3, we'll talk about the creation of express trust. Okay, so we're going to end here. And that's it for today, you guys. Again, make sure you hit the like buttons, share this information out with those that you feel need to hear it. Also, if you'd like to make a donation, just to be generous to, my time and show your appreciation, you may do so by Cash App or through Chime. That information is again in the description area of the video. Again, with that being said, it is your girl Empress Shay Marie, and I will see you all later. Holler back. Enjoy the rest of your day.